Imagine a quiet Tuesday afternoon in the city of Silveridge. You are walking along the sidewalk of Oak Avenue when you notice a police cruiser with its lights flashing. Two officers have pulled over a motorist and are beginning a search of the vehicle. As a concerned citizen interested in transparency and public accountability, you reach into your pocket, pull out your smartphone, and begin recording the scene from a distance of 20 feet. Within moments, one of the officers looks up, catches your eye, and begins walking toward you with a stern expression. They tell you to put the phone away, claiming that you are interfering with their investigation or that recording their faces is a violation of their privacy. This scenario plays out in cities across the country every day, creating a high-stakes environment where the line between a citizen's constitutional rights and a law enforcement officer's authority often becomes blurred. Understanding how to navigate this confrontation is not just about knowing your rights, it is about having a tactical communication strategy that protects you from unlawful arrest, while ensuring the interaction remains as safe as possible for everyone involved. The tension often begins because of the inherent power dynamic present during police encounters. When an officer tells you to stop recording, it is rarely based on a legitimate legal statute that forbids the act of filming in public. Instead, these commands often stem from a combination of psychological factors and a desire for control over the environment. Officers are trained to maintain scene integrity, which means they want to eliminate any distractions or variables that could complicate an arrest or a search. To many officers, a camera represents an unpredictable variable, an independent witness that they cannot control. Some officers may feel that being recorded makes them more vulnerable to complaints, or that it puts their personal safety at risk by exposing their identity. There is also the simple human element of discomfort. Very few people enjoy being filmed while performing a high-pressure job. However, personal discomfort or a general desire for control does not override the United States Constitution. When an officer tells you to stop, they are often testing your resolve or operating under a mistaken understanding of their own power. They may cite wiretapping laws or privacy rights, but in the context of a public sidewalk, these arguments almost always fail to hold up under legal scrutiny. To understand why you have the right to stand your ground, you must look at the legal precedents that have shaped American law over the last 2 decades. The landmark case of Glick versus Cuniff is perhaps the most significant. In 2011, the U.S. Court of Appeals for the First Circuit ruled on a case involving Simon Glick, who was arrested for using his cell phone to record police officers punching a suspect on the Boston Common. The court's decision was unequivocal. The First Amendment protects the right to film government officials, including law enforcement officers, in the discharge of their duties in a public space. The court noted that the gathering of information about government affairs, particularly the actions of the police, is a fundamental pillar of a free society. This ruling was vital because it helped establish the clearly established right required to overcome qualified immunity. Following this, the case of Turner versus Driver in 2017 further solidified this right in the Fifth Circuit. In this instance, Philip Turner was detained for filming a police station from a public sidewalk. The court affirmed that the First Amendment encompasses a right to record public officials, provided that the recording does not interfere with the officer's legitimate duties. These cases, along with similar rulings in the 7th, 9th, and 11th circuits, have created a powerful legal shield for citizens, making it clear that a badge does not grant an officer the power to turn off the First Amendment. However, no constitutional right is absolute, and there are 2 primary legal exceptions that citizens must be aware of to avoid legitimate criminal charges: interference and private property. Interference, often referred to as obstruction of justice, is the most common justification used to stop a recording. While the law allows you to record, it does not allow you to physically get in the way of an officer's work. If you are standing so close that an officer cannot move freely, or if you are shouting so loudly that the officers cannot hear their radio communications, you may be crossing the line from documenting to interfering. The key is to maintain a reasonable distance and remain relatively quiet. The second exception involves the nature of the location. The First Amendment right to record is strongest in traditional public forums like sidewalks, parks, and plazas. If you enter private property, such as a shopping mall or a private residence, the owner has the right to set the rules for photography and recording. If a store manager asks you to leave because you are filming and you refuse, you could be charged with trespassing, regardless of whether you are filming the police. Understanding the geography of your rights is essential. As long as your feet are on public concrete and your body is at a safe distance, your right to record is at its peak. When an officer approaches you and demands that you stop recording, your response should be calm, professional, and rooted in specific legal language. This is where the script becomes your most valuable tool. The goal is to create a verbal record on your video that demonstrates you are a law-abiding citizen exercising a known right. If the officer says, "Put that camera away," your first response should be, "Officer, I am documenting this event from a safe distance for the purpose of public accountability. I am on public property and I am not interfering with your duties." This statement immediately establishes three things: your intent, your location, and your awareness of the interference standard. If the officer continues to pressure you, asking for your identification or telling you that you are being suspicious, you should transition to a clarifying question. "Officer, am I being detained or am I free to go?" This is a critical legal juncture. If the officer says you are free to go, you should slowly back away while continuing to record, maintaining that safe distance. If the officer says you are detained, you have the right to ask, "What is your reasonable, articulable suspicion that I have committed, am committing, or am about to commit a crime?" Under the Fourth Amendment, an officer cannot transition a consensual encounter into a detention without a specific legal reason. Simply recording the police is not by itself a suspicious activity that warrants a detention. As the interaction continues, the officer may attempt to escalate the situation by demanding to see your phone or claiming it is evidence. In this moment, you must be firm about your Fourth Amendment rights. You should state clearly, "I do not consent to any searches of my person or my property, and I do not consent to the seizure of my mobile device." Following the Supreme Court's decision in Riley v. California, the police generally need a warrant to search the digital contents of a cell phone, even during an arrest. If an officer reaches for your phone, do not physically resist, as this could lead to a resisting arrest charge or physical harm. Instead, use your voice to document the lack of consent. Say, "I am not resisting you, but I am not consenting to this seizure. I am complying under protest." This phrasing is vital for any future legal action, as it proves that you did not voluntarily give up your rights. It is also wise to mention, "I wish to remain silent and I would like to speak with an attorney." Once you have invoked your right to silence, stop talking. Anything you say after that point can be used against you, but your silence cannot be used as an admission of guilt. Handling escalation requires a high level of emotional intelligence. If an officer gets in your face or tries to intimidate you with their physical presence, maintain your composure. Do not make sudden movements. Keep your hands visible at all times, preferably holding the camera steady. If you feel the situation is becoming dangerous, you can narrate what is happening. "For the record, the officer is now 2 inches from my face and is making me feel unsafe, despite my peaceful stance on this public sidewalk." This narration provides context for anyone watching the video later, including a judge or a jury. It is also important to remember the time, place, and manner doctrine. While the government cannot ban recording, they can place narrow restrictions on it if there is a compelling state interest. For example, if there is a high-speed chase ending in a shootout, an officer might order everyone to clear the area for safety. In such an extreme case, you should comply with the order to move, but you can continue to record from the new further location. The right to record does not give you a get-out-of-jail-free card for valid safety orders, but those orders must be applied neutrally and not simply because the officer dislikes the camera. In conclusion, the First Amendment is a powerful tool for transparency, but it requires a citizen who is both brave and informed. By understanding the precedents set by cases like Glick and Turner, recognizing the difference between public and private property, and using a disciplined script to assert your rights, you can protect yourself from the overreach of authority. Always remember that your phone is a witness that does not blink and does not forget. When you use it correctly, by staying back, staying calm, and staying silent when necessary, you are not just recording a video, you are participating in the vital democratic process of holding the powerful accountable. Whether you are on Oak Avenue in Silveridge or a busy street in a major metropolis, the law stays the same. The Constitution follows you onto every public sidewalk, and as long as you act with knowledge and restraint, you have the legal right to keep the lens open and the record clear. Protecting your rights during a law enforcement encounter is a skill that combines legal knowledge with the presence of mind to remain calm under pressure. By mastering the script and understanding the nuances of interference and seizure, you ensure that the balance of power remains where it belongs, in the hands of a well-informed and vigilant public. This strategy is your best defense against intimidation and your greatest contribution to the cause of civil liberties in the modern age. Keep your camera steady, your voice calm, and your rights at the forefront of every interaction.